All right, so I'm going to do 4 because it's easy, it's short, it's special proceedings. 4.1, parties. The party commencing a special proceeding shall be styled the petitioner and any adverse party the respondent. After a proceeding is commenced, no party shall be joined or interpleaded, and no third-party practice or intervention shall be allowed except by leave of court. 402. There shall be a 402. Pleadings. There shall be a petition which shall substantially conform. Oh no, it just says which shall comply with the requirements for the complaint in an action, and an answer where there is an adverse party. There shall be a reply to a counterclaim denominated as such, and there may be a reply to a new matter in the answer in any case. The court may permit other pleadings. Where there is no adverse party, the petition shall state the results of any prior application for similar relief and shall specify the new facts, if any, which were not previously shown. 403. Notice of petition, service, order to show cause. A. Notice of petition shall specify the time and place of the hearing and the supporting affidavits, if any. B. Time for service. A notice of petition shall be served on any adverse party at least 8 days before the time the petition is noticed to be heard. Answer and supporting affidavits shall be served 2 days before such time. A reply shall be served at or before such time. An answer shall be served at least 7 days if the petition is served. An answer shall be served at least 7 days before such time if a notice of petition served at least 12 days so demands, whereby any reply shall be served at least 1 day before such time. Motions is 1671 and 820. This is still 1271 and 820. C. Manner of service. A notice of petition shall be served in the same manner as a summons in an action. D. OSC. The court may grant an OSC to be served in lieu of a notice of petition at a time and in a manner specified therein. 4. Objections in point of law. A. By respondent. The respondent may raise an objection to a point of law by setting it forth in his answer, or by a motion to dismiss the petition made upon notice within the time to answer. If the motion is denied, the court may permit the respondent to answer, and unless the order specifies otherwise, such answer shall be served and filed within 5 days after service of the, and he makes it on the day when the petition has been noticed or re-noticed to be heard. 406. Motions in a special proceeding made before the time shall be noticed to be heard at the time the petition is noticed to be heard. 406. Motions in a special proceeding which are made before the return date shall be noticed to be heard on the return date. 407. Severance. The court may at any time order a severance of a claim, counterclaim, or cross-claim, or as to a particular party, and order that such special proceeding continue as an action or as a separate special proceeding. 408. Disclosure. Leave of court shall be required for disclosure except for a notice under 3123, which I think is a notice to admit. A notice under 3123 may be served at any time, not later than 3 days before the petition is noticed to be heard, and the statement denying or setting forth the reasons for failing to admit or deny, yes, it is that, shall be served not later than 1 day before the petition is noticed to be heard, unless the court otherwise orders, made by motion without notice. So you can make an order to show cause, and the court can rule on that. So if you get the notice to admit and you don't want to respond to it, you can make an order to show cause, and the court may order that you don't have to. So the exceptions here are proceedings in a surrogate's court, or proceedings relating to an express trust. And those are governed by Article 31. Oh, and the reason for that is because I guess the legislature decided back in 1976 that there's no good reason why the procedure inter vivos trust accounting should be different from testamentary trust accountings. 4.9. Hearing. A. Furnishing of papers filing. Upon the hearing, each party shall furnish to the court all papers served by him. The petitioner shall furnish all of the papers not already in possession of the court necessary to the consideration of the questions involved. So in English, that just means they have to give the court their papers. The court may require submission of additional proof. All papers furnished to the court shall be filed unless the court orders otherwise. B. Summary determination. The court shall make a summary determination to the extent that no triable issues of fact are raised. The court may make any orders permitted on a motion for summary judgment. 4.10. Trial. If there are triable issues of fact, they shall be forthwith tried, and the court shall make a final determination thereon. If they're right by jury, there's a right to jury trial on some of these fact issues. The court shall give the parties an opportunity to demand a jury trial. Failure to make the demand shall be deemed a waiver of the right to jury trial. 4.11. Judgment. 4.11. Judgment. The court shall direct that a judgment be entered determining the rights of the parties to the special proceeding.